Welcome, everybody. My name is Kamila Sekovich. I am the Executive Director of the Internet Commerce Association, the ICA. We are thrilled to have all of you here with us today for the second Levine Lecture. For those of you who might not be as familiar with our organization, the ICA is dedicated to advocating for domain name registrants and also for fair processes within the domain name industry. And one of our key focuses is the UDRP. And we work hard to ensure that the UDRP remains a balanced and fair process for all the parties involved. I am very thankful, grateful to have David here with us, David Bernstein, to do the lecture. Welcome, David. Thank you for taking the time. We also have Gerry Levine and WIPO's Brian Beckham. I wanted to say David. And of course, ICA's General Counsel, Zak Muscovitch. Let's prepare. So without further ado, I will turn it over to ICA's General Counsel, Zak Muscovitch.
Well, thank you, Camila. We're hoping to have David Beckham next year, but this year we're very fortunate to have David Bernstein. Thank you so much for doing us the honor of being the second Levine lecturer this year. It's much appreciated, David. And thank you, Brian, for agreeing to give the introduction to David momentarily. So the Levine Lecture last year was presented by Tony Willoughby, who led us down just a delightful historical memory lane of the UDRP and even prior to the UDRP and cyber squatting. And so we're looking forward to an invigorating lecture from David today. The idea behind the Levine Lecture came, I got a call just before COVID really took its grip from Gerry and said, we should have a weekly call to discuss UDRP cases and UDRP law. And over the last number of years, I've got to know Gerry very well and really developed a profound respect for his scholarly activities. He is the author of a tremendous tome. This is his latest Clash of Trademarks. He's also counsel, he's a panelist, and the idea behind the Levine Lectures is to really present a thought-provoking, sometimes controversial, but really thought-leading discussion on the UDRP. And that's really what Gerry exemplifies with his attention to the UDRP and his dedication to it over the years. And that's why today we've selected David Bernstein, who's very much in that tradition of thought-provoking, of thought leadership, and dedication to the UDRP. And no one's more familiar with that than Brian Beckham. So I'll allow Brian Beckham to formally introduce David right now. Thank you, Brian.
Thank you very much, Camila. Thank you, Zak. Thank you, Gerry. So many of you will know that David Bernstein chairs the intellectual property group at Dev Boys in Plimpton and is widely recognized as one of the top IP litigators in the country. Many well-deserving accolades have been used to describe David, but my favorite is the Wizard of Trademark Law. And I can tell you that there is a true gentleman and a true scholar behind the curtain with David. David has been involved with WIPO and the UDRP since the very beginning and has authored over 250 decisions for WIPO, including some of the most important and most cited decisions which remain relevant today. David has contributed to the WIPO jurisprudential overview, and we have had the pleasure of his being the co-lead for WIPO's Advanced UDRP workshop over the years. Above all that, David brings a true joy and passion for the law of trademarks, domain names, and free speech. He is always thoughtful and genuine, and I can tell you from experience, he is also a remarkably competent and fast skier. I cannot wait to hear what David has to say and already wish to thank him in advance. David?
Wow. Well, Brian, thank you for that very generous introduction, and Zak and Camila for inviting me to speak. And of course, Gerry, what an honor to be here speaking in your honor with your amazing scholarship that has done so much to advance the law around the domain names and the UDRP. It's pretty extraordinary that earlier this year, we celebrated the 25th anniversary of the UDRP. I see from the folks who have signed on, many of you were at that session in Geneva. It was a very special opportunity to look back, but also to look forward. And I'd like to do some of that today. Many of you are digital natives. You grew up in the internet world. You've only known an internet world. But when I started practicing law back in 1990, we didn't have the commercial internet. I grew up learning trademark law, IRL, as my children would say. We didn't have a virtual world back then. And so I'm a digital immigrant. I come to the digital world with a host of pre-digital experiences. But my initial approach to thinking about problems in the online world was usually to try to analogize them to problems that we had already grappled with and dealt with in the real world. And that usually worked just fine. And when it came to domain names, there was a little bit of a disconnect. So one of my early domain name cases was in the early 1990s. Here in the United States, we have a bunch of companies that do test preparation for students, helping them with their tests for admission to college or to graduate schools. And one of them was the Princeton Review, and another one was Stanley Kaplan. And Princeton Review registered the domain name kaplan.com. And when students came to kaplan.com, they would promote the Princeton Review. Now, at that time in the early 1990s, very few people had access to the internet, but students at universities did. And that was, of course, the market that Princeton Review was going for. And the analogy to the real world worked just fine with this domain name dispute. Princeton Review's registration was classic trademark infringement. They were using their competitor's name in the domain name to confuse students about the source of the domain name, and then they operated a bait and switch. And through trademark litigation, because we didn't have the UDRP back then, we recaptured the Kaplan.com name for Stanley Kaplan. After that, Princeton Review had a new idea. They threatened to register Kraplin.com. And once again, we had a real world solution to that. We let them know that a registration like that would violate trademark dilution law by associating the Kaplan name with crap. And I'm happy to say they abandoned that mean-spirited plan. So as we can see, trademark infringement can be at the heart of a domain name dispute. And even though the Kaplan case was resolved through claims of trademark infringement, it was very much what we would consider cyber squatting today, the bad faith, abusive registration and use of a domain name. But the effort to apply these traditional trademark laws to online violations was not always a good fit. Another case I had in the early 1990s involved the registration of the domain name avon.com. Now, we never found out who registered it. All we knew was that they were somewhere in Brooklyn, and they never used it. So this was classic passive holding. Long before Andrew Christie's seminal Telstra.com decision, this was literally cyber squatting. The registrant squatted on the avon.com name, but didn't use it at all. And we weren't really sure what to do about that. It wasn't trademark infringement because there was no use that we could point to. And we tried to fashion a trademark dilution claim, but that was pretty hard in the absence of any use at all. Now, I will say, ultimately, we did recapture that name for Avon, but it showed us that there was a significant gap in the ability of trademark law to address disputes over bad faith registration and use of all domain names. Now, journalist Josh Quittner over at Wired Magazine, he saw that gap as well. He famously noted in a 1994 article in Wired Magazine that McDonald's.com was not registered. And he tried to interest McDonald's in registering the name, but it was to no avail. And he actually finally registered it himself. All of this domain name activity in the early 1990s might have seemed a little surprising because there was no commercial internet back then. I remember, in fact, having to arrange a special phone line to be installed in my office so I could dial up through MindSpring to get access to the internet. And I don't know why I bothered, because there was nothing to see other than some chat boards. And a little later in the 1990s, some of these chat boards started to have rudimentary banner ads, and we had some litigation over those banner ads, but none of it was too exciting. But the visionaries who were active in the 90s knew that something big was coming. And one of them, of course, was Francis Gerry, who was then the head of WIPO's Arbitration and Mediation Center. And Francis is the founding parent of the UDRP. He envisioned the idea of this administrative proceeding that could be enforced through a series of contractual relationships, from ICANN to the registries, to the registrars, to the registrants, and that would provide an efficient, an expeditious, and a fair method of resolving cybersquatting disputes. And I was very fortunate to have the opportunity to consult with Francis's colleague, Deborah Enix-Ross, who traveled the world meeting with leading trademark scholars and practitioners while developing the specifics of the UDRP. And I was, as Brian mentioned, honored to be among the first group of panelists. And those of us who were the early participants in the UDRP, we thought this would be a pretty quick endeavor. There had been a raft of cyber squatting in the late 90s, just as the commercial internet was really bursting onto the scene, perhaps fueled by Quittner's identification of the coming tsunami of domain name registrations. And we thought we'd get a bunch of complaints to address the existing cyber squatted names. We'd clean those up. We'd issue decisions, which ones should be transferred, which ones could be kept because they were legitimate or not in bad faith. Brand owners would have their domains back. We could pack up and go home. Well, it didn't work out that way. Just like the internet is far more complex today than it was in the chat board and banner ad era of the late 90s, so is cyber squatting far more complex. There are many, many more gTLDs and ccTLDs. Domain names are now fully internationalized, and they're registered in many languages and scripts. There are many more registrars all around the world, which registration agreements are in virtually every language, and correspondingly, we have the need for panelists who can speak nearly every language. GDPR and the rise of privacy services for domain name registration has greatly complicated the ability to identify who a registrant is and to research the extent to which that registrant may have engaged in a pattern of bad faith activities. And there's been an explosion in the use of the internet for information, for e-commerce, and pretty much for everything. And with all of that has come the opportunities for name conflicts in the domain name space, and there's far more of them. And also, there are more sophisticated ways that brand owners are using domain names, and more sophisticated ways that bad actors are using domain names. Now, this increasingly sophisticated nature of online bad faith conduct has led to UDRP cases that are more difficult than they were in those early days. Now, to be fair, I'm talking about a very small sliver of these cases. The vast majority of UDRP cases are quite straightforward. There are frequently defaults, and there frequently is very little dispute about the nature of the misconduct. Indeed, these cases are so routine, and there are so many of them, that I wonder whether some Gen AI agent will be able to adjudicate these cases at lower cost in the not too distant future. But there remains a small number of cases that raise complex issues or disputed facts, or that are close cases on the merits. Those are the majority of the cases that I see, and that might explain why my rate of decision awarding transfer is so different from the average. I believe something like 95% of UDRP cases end in transfer these days. And that reflects that the majority of these cases are pretty straightforward. But on my docket, at least, it's pretty close to an even split. I think I've ruled for respondent about half of the cases I've handled. Brian mentioned I've got almost 300 at WIPO. I've got more than 100 with some of the other providers. And among my 400 or so cases, not only do I rule for respondents about half the time, but I've made findings of reverse domain name hijacking in dozens and dozens of those cases. Now, perhaps that's because I'm frequently selected by the parties on 3-member panel cases that I tend to get an outsized number of what I would characterize as these close cases or cases with hotly disputed facts. And among those are cases where there are allegations of trademark infringement. Now, in some of those cases, the parties dispute the extent to which allegations of trademark infringement are relevant to the issue of cyber squatting. Those are the issues I'd like to address in the lecture today in Gerry's honor. How should panelists address cases with disputed facts, given that this is an expedited proceeding based only on written submissions, without discovery, without live testimony? How should panelists rule in those cases where the facts are not entirely clear? And what role do allegations of trademark infringement play in the UDRP? All right, let me start with cases of disputed facts. Actually, almost every case has them. Even if the respondent defaults, even if there's no response, the panelists still must assess the allegations of the complaint and determine whether the complainant has proven all three elements of the UDRP. Indeed, I and other panelists have ruled for respondents in cases where there's no response, because the complainant has not carried its burden of proof on all three elements. The complainant might have thought the facts were pretty clear, and yet the panel still is able to recognize that they're disputed and they may have been unproven. Now, just because the facts are disputed does not mean we should automatically rule for one party or the other. Indeed, Gerry himself has recognized in his book that the complexity of the factual circumstances is not itself a reason for abdicating making a decision. And I don't think Gerry's proposition is controversial. Panelists will assess the evidence and do the best they can with the evidence that they have to resolve whatever disputes of fact there may be. And the evidence we can look at can include the statements in the parties' pleadings, as long as they're certified to be accurate. It can include affidavits or declarations of the parties, as long as they're sworn to be true. And it can include documentary evidence substantiating those allegations of fact. Now, sometimes, even after looking at all of that, the facts are not clear. And that may fall into the category of what people call close cases. For example, I had a case some years ago. It involved the domain name TribecaFilmCenter.com, a well-known film center here in New York. And the complainant swore that the respondent offered to sell the domain name for an amount in excess of the registration costs. If true, that would be classic bad faith use under the UDRP. But the respondent vehemently denied having made an offer of sale. The parties didn't give me any emails between them to show the offer of sale. They said it was done on a phone call. There were no internal emails that helped me to decide how to resolve this he said, she said dispute. There were no notes of the call that were submitted to me, or no email, for example, within the complainant organization where one person reported to another contemporaneously, here's what the guy said to me in the call. I was not able to see any evidence at all to help me assess who was telling the truth. Was there an offer to sell made on that phone call, or was there not? And I looked at all the other facts in the case, and I couldn't assess from the other facts whether the offer for sale had occurred. There were no post-offer communications that made it clear to me that, yes, there had been an offer for sale. And also, neither party approached the UDRP process in a way that undermined their credibility. I will say I see that a lot. I see parties making outrageous assertions of fact or outrageous assertions of law where they dispute every single element, even when there's no credible basis to support that. And when I see that, when a party loses credibility in one part of its submissions, that loss of credibility can certainly taint my view of the facts across the case. But it didn't happen here. Really, all I had was a toss-up. I had one party saying one thing and another party saying another thing, and I just could not tell on the record who was telling the truth. There was no discovery, so the parties couldn't shed light on that, and there was no live testimony, so I couldn't assess credibility. In those circumstances, the decision ultimately comes down to what is the burden of proof. It is well accepted in the UDRP that the burden of proving all three elements is on the complainant. And that burden is sometimes called the on balance standard or the preponderance of the evidence standard, but essentially it's the scales of justice. When the scales of justice weigh one way or the other, the panel should decide the case in the direction that has the most weight, even if it's close. Even if it's 51% one way and 49% the other way. If the scales, if the weight of the evidence goes one way or the other way, if it tilts, then I'm going to do the best I can as a panelist, and I think that's the job of all panelists, and decide how do I assess the facts. But where it's truly a toss-up, a 50-50 split, where it's impossible for me to assess how the scales tip, then the panel should rule that the complainant has failed to carry its burden of proof by a preponderance of the evidence. There is no preponderance when it's a split. And it's not just me who feels that way. I think this is pretty well accepted across panelists. For example, in the Forex case, where the complainant didn't have a trademark registration in the US for Ferox, sorry, not Forex, Ferox, F-E-R-O-X. And the complainant said, oh, I'm a well-known investment management firm, and I operate in places where the complainant should know about me. But there was no evidence. It was just a bald, conclusory statement. There was no evidence of fact to support it up. And in the absence of that evidence, the panel said, well, I've got to give equal weight to what the respondent says, which is that they chose the name Ferox as a logo depicting a gray fox. And they selected that name with good faith, without any knowledge of the complainant. And in the absence of evidence, the panel said, I can't tell which way I'm going to credit the respondent. I understand what the complainant is saying. Neither one of them has provided evidence to support their statements. But in the absence of that, given the limited evidence of the record, the complainant hasn't established the respondent's lack of rights or legitimate interest. And therefore, again, the burden of proof ultimately was one of the key issues in that case. Now, I don't think this should be controversial. How do we deal with close cases? As with cases involving disputed facts, if the issues are close, if the panel, can do the best it can with the evidence presented, it can make the findings of fact on the record. And if the complainant or the respondent failed to come forward with relevant evidence, then that's their problem. The panel can only deal with the evidence as the parties have presented it. And if the parties don't like it, they generally can go pursue that matter in court, where they can develop a more robust record. But what I do not agree with is the suggestion, which I sometimes see in some of the commentary, including here at the ICA, that the UDRP is only designed to address clear cases of cybersquatting. And therefore, if the case is close, the benefit of the doubt should go to the respondent, and the panel should deny the complaint. I don't agree with that. It is true that the constituent documents talked about the UDRP being designed to address clear cases of abusive bad faith registration and use of domain names. But what comes from that is the development of the stringent three-factor standard, where the complainant has to prove by a preponderance of the evidence, all three factors, that the domain name is identical or confusingly similar to a trademark in which the complainant has rights, that the respondent lacks rights or legitimate interest in the domain name, and that the respondent both registered and used the domain name in bad faith. These three elements are the result of the obligation of saying we only will use the UDRP for clear cases of cybersquatting. But that doesn't mean that the burden of proof is any different. The burden of proof is still the preponderance of the evidence. Once we are looking at those three factors, the question is, has the complainant carried its burden of proof? The complainant does not have to prove anything by clear and convincing evidence. That's the express standard in the URS, but it is not the standard of proof in the UDRP. And for that reason, no matter how close the case might be, in my view, the panel has to do the best it can with the evidence presented, hold the complainant to its burden of proof, and decide the issues presented even if they're close. All right, so that brings me to my third topic for today. And that is, what is the relevance of allegations of trademark infringement in the UDRP? Now, some panels have refused to consider allegations of trademark infringement, saying that it's beyond the scope of the policy. And there's been a fair amount of commentary around that as well. For example, there was a case involving the trademark family watchdog the complainant owned a trademark family watchdog for use with security services and creating sex offender maps, and said that the respondent had no right to use the domain names familywatchdog.com, .net, and .org. The respondent allegedly was engaged in a series of potentially unfair business practices. The complainant said they were trying to profit off of the success and the media appearances of the complainant and cause confusion of consumers who are visiting respondent's website. The panel said that the policy is limited to cases of abusive registration and cybersquatting, not trademark infringement. And this dispute involved broad factual and legal issues respecting trademark rights and usage. And the panel decided that the domain name dispute was ancillary to the trademark disputes between the parties, and therefore that the entire dispute was beyond the scope of the policy, and the panel denied the complaint. Similarly, in Reshape Wealth, the complainant claimed rights in the trademark Reshape and had the domain name reshapewealth.com. The respondent was a VC firm, and they registered reshape.co under the Colombian CCTLD. And the complainant said, oh, that is identical to our trademark. It confuses consumers. It violates our trademark rights. And the panel said, well, that's a trademark dispute. That has to be heard in a different forum. It can't be heard in the UDRP. The UDRP is limited to deciding whether domain names were registered and used in bad faith. Trademark infringement is outside the scope. I think that goes too far. I think that in those cases, the panel should and could decide the issues, being honest to the factors of the UDRP, but taking into account the extent to which allegations of trademark infringement are relevant to the 3 UDRP factors. To the extent those cases or some of the commentary that I've seen is understood as saying that panelists can't consider allegations of trademark infringement at all, that if there's a case of trademark infringement, we should say, whoa, that's outside the policy, take that somewhere else, I think that's wrong. Now, it's definitely true, and I've written this in a number of decisions, that the UDRP is not a general domain name court. Panels are not constituted to decide all disputes that are related to domain name. Rather, panels are tasked with assessing only disputes under the policy, whether the complainant has shown rights in a trademark, whether the complainant has shown that the domain name is identical or confusingly similar to that trademark, whether the complainant has shown that the respondent lacks rights or legitimate interest in the domain name, and whether the complainant has shown the respondent registered and used the domain name in bad faith. And I submit that each of these elements has aspects that are informed by trademark and trademark infringement law. For example, let's take the very first element, whether the complainant has trademark rights. That's uniquely an issue of national law. Has the complainant shown that it has trademark rights based on the laws of the jurisdiction where it operates? That might be proven with a trademark registration, although only if the registration evidences trademark rights. That's why U.S. federal supplemental registrations are not sufficient to establish trademark rights. There's no prima facie validity to a supplemental registration. We are bringing in these elements of trademark infringement law when we're deciding this issue. It's also why U.S. state registrations are often found not to be sufficient, because there's no examination, and they're not persuasive evidence of trademark rights in the absence of some showing of use in commerce and of distinctiveness. Trademark rights also can be proven through common law rights, but again, that is a question of national law. What is required to show common law rights in the jurisdictions where you operate? And have you submitted factual evidence to show use and distinctiveness, for example? Conclusory allegations are not enough. Just saying, I have common law rights in the trademark X, Y, and Z, that's never going to be enough because that's not a fact, that's just a conclusory allegation. And so in the first part of the first element, we're considering issues of trademark law. And similarly, when we're looking at whether the domain name is confusingly similar, issues of trademark infringement have been discussed as well. Although here it's actually in the negative. So what do I mean by that? As the decision overview makes clear, the test under the first factor is a reasoned but relatively straightforward comparison between the complainant's trademark and the disputed domain name. This is not the place where we go through the full likelihood of confusion analysis that is part of trademark infringement law. Indeed, panels have said that confusing similarity for purposes of the policy is just a standing element, that issues related to likelihood of confusion, those will be considered in the second and third elements when we get to questions of illegitimacy and bad faith. In other words, decisions on this first element recognize that the likelihood of confusion factors, which are standard part of trademark infringement law, those will be assessed in the UDRP, but they will be assessed when we turn to the second and third factors. So let me turn to the second factor. And I'm going to focus on paragraph 4C1 of the policy, which states that a respondent can show rights or legitimate interest in a domain name if the respondent can show that before any notice to them of the dispute, they used or made demonstrable preparations to use the domain name or a name corresponding to the domain name in connection with a bona fide offering of goods or services. And paragraph 4C3 also has elements of trademark law in it because it provides another way in which a respondent can have rights or legitimate interests. If they're making a legitimate non-commercial or fair use of the domain name without intent for commercial gain to misleadingly divert consumers or to tarnish the trademark at issue. Both of these examples of rights or legitimate interests are based in and derive from classic issues in trademark infringement jurisprudence. And for me, the real crux is in 4C1, which talks about the use or the demonstrable use being bona fide. Now, we've seen a number of examples from cases of uses that are not bona fide or that are bona fide. For example, it's well accepted that the sale of counterfeits is not a bona fide use. Just because the respondent was selling counterfeits under the brand name at a website prior to notice of the dispute, that doesn't mean that they can rely on 4C1 and say, hey, I was using the domain name in my business before notice of this dispute. If that use was not bona fide, it's not enough to show right to legitimate interest under paragraph 4C1. I think that's very well accepted. And that's because counterfeits are never bona fide. Counterfeiting is an egregious form of trademark infringement. It's a type of infringement where the mark at issue is not only confusingly similar, but it's identical. It's a slavish copy. And the seller is passing those goods off as being from the brand owner. When panelists are assessing whether a mark is counterfeit, and therefore whether the offering of goods or services is bona fide, they are making a trademark infringement analysis. And one example is a 3-member panel I sat on. It involved the domain name voguecatch.com. And the question was, has the complainant proven that there's counterfeiting here? Now, there had been a prior case, it was a Karen Milken case, if I recall, where the panel said, you need to submit evidence of a trap purchase, showing that the complainant went out and bought the good and got it and examined it and confirmed that it was counterfeiting. And in Vogue Catch, the panel I was on, it was a 3-member panel, as I mentioned, said, no, that goes too far. All we need is to see, has the complainant alleged sufficient facts to show that there is likely counterfeiting going on here. Simply saying it's counterfeit is not enough. We need some facts, but there can be circumstantial evidence of counterfeiting, such as looking at the images that are posted online or looking at the pricing being way too low, for example. And so the question there was, if the panel assesses all of the facts of the record, can we assess that this was likely an infringing or even a counterfeit sale and therefore not bona fide? And on the flip side, we've used trademark infringement law to decide whether some things are bona fide. For example, the resale of branded goods is a huge issue in many of these cases. And it goes back to the Okidata case, which has long been seen as the appropriate standard for assessing whether the authorized or even the unauthorized sale of branded goods can be bona fide. And if it is, it can be legitimate. And in Okidata, I set out 4 principles, all derived from trademark infringement law, to try to assess, is this use bona fide? Is the respondent offering goods or services that use the brand? And are they only using it to sell those goods and services? Is the website deceiving consumers about the source of the website or of the goods? And is the respondent trying to corner the market on all the domain names reflecting the trademark? This was a way of looking at whether the use was fair, derived from a lot of principles that had been developed over many years of trademark infringement jurisprudence, and whether the sale of those branded goods, even by a third party, is bona fide or not. And in that case, of course, I found that it was bona fide, and therefore, even though the respondent was using Okidata in the domain name without the authorization of the brand owner, that they had a legitimate interest in doing so. Now, the flip, again, is that if the use is infringing, it's not bona fide. And I had a recent case that raised this issue, which was the domain name was narasmith.com. Narasmith is a model and an online influencer. She doesn't have or didn't register the trademark Narasmith, but she did show that she did have sufficient evidence to show common law rights in the trademark Narasmith. And the respondent had a pending trademark application for Narasmith Organica's skincare, and she had a website set up that looked like it was ready to sell skincare items under the Narasmith name. Now, her efforts to actually launch that website appear to have been delayed because of some health issues, but one might have looked at this and said, by virtue of the fact that she applied to register her trademark with the US Patent and Trademark Office, she had to pay money for that. She had to sign a statement saying that she uses or intends to use the mark, and that she intended to use it in connection with a bona fide sale of goods, and that she actually had put together a website. One might have said that that's enough to show demonstrable preparations. But for me, the question was not simply, has she made demonstrable preparations to use the mark, but rather whether the demonstrable preparations were to use the mark in a bona fide way. And I found that they were not on the evidence presented. I found that her use of Narasmith constituted trademark infringement. And as such, an infringing use is not a bona fide use. Allegations of trademark infringement were centrally relevant to my assessment of whether or not the use or the demonstrable preparations to use were bona fide. And this has come up in other cases as well. I had a case involving a Vietnamese party who had the website, the domain name oncloudcare.com, and they were selling sneakers. And the plaintiff, On AG, the Swiss company that sells on-cloud sneakers, they said this is trademark infringement. And I found indeed it was infringement, and therefore it could not be bona fide. And some years ago, I was on another case. It was a 3-member panel involving a party in Canada who was selling soy milk at the domain name soylifeca.com. And the panel found that infringed the complainant's registered Soy Life trademark, and that trademark infringement is not a bona fide use, even though they were in fact selling soy milk before the notice of the complaint. I don't think this concept of bringing the standards of trademark infringement into the assessment of whether a use is bona fide should be controversial. Indeed, the policy itself has numerous references to concepts of trademark infringement law. For example, the policy warns registrants in paragraph 2 that they must not infringe upon or otherwise violate the rights of any third party. The word infringe is right there in the policy. Of course, we can consider allegations of trademark infringement in deciding whether or not the respondent has lived up to its representation when it registered the domain name that it will not infringe or the registration does not infringe or violate someone's rights. And the policy, when it talks about bad faith, uses concepts that come directly from trademark infringement law. It says that it is bad faith to use a domain name in a way that will create a likelihood of confusion with the complainant's mark as to source, sponsorship, affiliation, or endorsement of your website. Likelihood of confusion. This is the standard test of trademark infringement law. That's why in the very first element, we don't consider all the likelihood of confusion factors in deciding confusing similarity. We save those factors for deciding that in bad faith and in legitimacy, including whether or not the respondent is using the mark in a way that is likely to cause confusion. Now, this doesn't mean that just because a panel finds that a domain name constitutes trademark infringement and is therefore not bona fide, that doesn't mean that the respondent automatically loses. That only goes to the second element. Has the respondent shown rights or legitimate interest because it's making a bona fide use? If it's infringing, even if it's an innocent infringement, in my view, it's not bona fide. But the complainant still has to show bad faith under the third element. Again, that's why the policy was designed to address clear examples of abuse of registration. If it's an innocent infringement, maybe that is something that has to be decided in court. Maybe that is something that's not appropriate for the policy, because the policy requires both registration and use in bad faith, as well as the absence of legitimacy if the goods are not bona fide. And therefore, the key issue on the third element is, can the complainant show that the respondent registered and used the domain name in bad faith, which requires knowledge of the respondent and its trademark rights, or at least willful blindness towards those rights? And two of my cases illustrate this point, illustrate the point that a domain name could be not bona fide because it's infringing, but it may nevertheless not be bad faith for purposes of the policy. So one of them is a case I had with WIPO some years ago. It's from 2021. And the domain name at issue was ejuicedb.com. And the complainant was an electronic cigarette producer, and they owned the trademark JuiceDB. So they also owned the domain name juicedb.com. The respondent was an electronic cigarette online retailer selling these vaping products, and the only difference between the respondent's domain name and the complainant's was the addition of the letter E before JuiceDB. So juicedb.com, ejuicedb.com. Now the complainant said the respondent's use of this domain name is not bona fide because it's infringing. And to the extent it was infringing because the complainant owned a trademark for JuiceDB, and the addition of the letter E before it, which is very common in the website world for an electronic version of something, that's infringing. It's not bona fide. But even though it wasn't bona fide, the respondent was successful in showing that it registered eJuiceDB without knowledge or willful blindness of the complainant's rights. That the respondent used that name because juice is a very common term for these vaping products, and DB is a common term for a database, and the respondent was offering a database of vaping juices and selling them on his website. And I found in that case that the critical issue was whether the respondent knew of the complainant and its trademark rights, and whether it selected the disputed domain name in order to take advantage of the goodwill in the complainant's rights and to confuse people, or whether the respondent registered ejuicedb.com with an absence of bad faith. I was going to say in good faith, although that's really wrong, right? The respondent doesn't have to prove good faith. It's just the absence of bad faith. And on the limited record before me, I found that the complainant had not proven that the respondent registered and used it in bad faith. Rather, I found credible the respondent's assertion that it selected that name for its descriptive meaning. So here's an example where the use of the domain name and the use of the ejuicedb.com name might very well be infringing. And had the complainant gone to court, I don't know if they did after my decision, they may very well have sustained a trademark infringement claim. But still, applying trademark infringement principles, I could find that although the use was not bona fide, nevertheless, it was not bad faith for purposes of the policy. Another one that I had very recently, just last year, involved the domain name praythevote2024.com and praythevote2024.org. And it was an interesting case. The complainant had a registered trademark for Pray the Vote, but the complainant failed to maintain its registration, and the registration was canceled. And the respondent was interested in using these domain names and was aware that the complainant had this registration, but it had been canceled. And so the respondent did some due diligence to try to figure out, does the complainant still have these rights or not? Because after all, if the respondent was going to register these domain names under paragraph 2 of the policy, it was going to be representing to ICANN and to the registrar and to the registry that its registration of these domain names would not infringe or otherwise violate someone's rights. And so they did their due diligence, and they saw that the registration was canceled, and they could not find any current use of the domain name. The website that was still up was very old. It hadn't been updated in years. There was no current content on it. And so they made the assessment, having done their due diligence, that the complainant no longer had trademark rights, and therefore they went ahead and registered. Now, the complainant, of course, came forward and sued under the UDRP, or filed a complaint under the UDRP, and said, hey, I never abandoned my trademark. I still have rights in Pray the Vote. I haven't updated the website because we didn't have an election, but we've got one now. And all of a sudden you're out there with these confusingly similar websites. You're infringing my trademark. And if the complainant did in fact still have trademark rights, then I would say that the respondent's use of Pray the Vote may very well have been infringement. So the key question for me was whether the respondent's registration of this domain name was bona fide. Did it infringe on the rights? And I said, even if infringement is unintentional, a use is not bona fide if it's infringing. But I specifically said issues of intent and knowledge will be highly relevant when we get to the issues of bad faith. And sure enough, when I got to the question of bad faith, I found that although the complainant had credible arguments that it had a trademark, the respondent had credible arguments that it did its due diligence and it didn't believe the complainant had trademark rights anymore, and therefore it did not register these domain names in bad faith to take advantage of the complainant's rights. Rather, the respondent showed that it registered these domain names because it wanted to host a website at which it would encourage people to pray for whatever the vote was going to be. What I wrote was that the respondent has provided a detailed explanation of its due diligence. And even if that due diligence, perhaps was a bit flawed, nevertheless, at the end of the day, they searched the USPTO database, they examined the website, they made a a fair conclusion that the complainant had no trademark rights. Now, they could have done more. They could have hired an investigator. They could have, contacted the complainant. But in my view, they weren't obligated to do that. They made a fair assessment that that this trademark was available, and the complainant failed to show that they registered it in bad faith. And I looked at all the other evidence as well. For example, the website didn't look confusingly similar to the old website. So it didn't look like they were trying to take advantage of rights that the complainant had. The logo that they adopted looked different from the logo that the complainant had used, for example, back on its website. So all of those elements helped to show that there was an absence of bad faith. So what I want to wrap up with is this notion that trademark infringement can indeed be relevant. When panels say allegations of infringement are beyond the scope of the UDRP, as a standalone assertion, I think that goes far too far. It is absolutely true that there are cases of trademark infringement involving domain names that are going to have to be resolved in court because they don't meet the stringent standard of the UDRP. And some of these cases are going to be hard. Some of them are going to have close calls. Some of them will have disputed facts. We as panelists will do the best we can with those facts to assess the evidence that we have. But that includes assessing the evidence to decide whether or not the complainant has shown that the use and registration of the domain name is trademark infringement and therefore not bona fide. And at the same time, the burden is on the complainant to show that the respondent did it in bad faith, that it wasn't an innocent infringement, potentially like the Parade the Vote case or the eJuice DB case, rather that it was done in bad faith with knowledge or at least willful blindness of the respondent's rights. I appreciate this is a somewhat nuanced issue, but the UDRP is nuanced. We have to decide hard cases. It's not like 1999 and 2000 when we were dealing with really super easy cases of cyber squatting. The internet is more complicated today. Cyber squatting is more complicated today. But as Gerry said, that doesn't mean we abdicate our responsibility as panelists. What it means is that we grapple with the evidence presented. We make the findings of fact that we can, best as we can. We apply the burden of proof. We hold the complainant to that burden. And if deciding the case requires us to consider issues of trademark infringement, there's no reason that that should be outside of the policy or that we should abdicate our responsibility and say the policy doesn't reach issues of infringement at all. Thank you all very much for your attention. I suspect I may have some questions and I'm happy to take them.
Well, thank you very much, Dave. That was just terrific, really thought-provoking. Just so everyone's aware, excuse me, we've had well over 100 participants, and a real testament to they all stayed and for the whole thing. And so now we'll ask a couple questions if we have some time before Gerry gives his closing remarks. Brian, do you have a question you'd like to ask?
Yeah, well, first of all, thank you, David. That was fascinating, especially the point about innocent infringement and the intersection of the second and third element. One of the things I was wondering about, you mentioned a few, I think, somewhat related concepts, the idea of conclusory allegations, insufficiently supported claims, and credibility. So I wonder if something comes to mind for you, what maybe are the contours for you when you might base a decision on an inference, when you might ask the parties for additional evidence or arguments on a specific point, or as you reminded us, the burden always lays with the complainant, when you might, as once was said by Richard Lyon in a case, leave the parties as you found them and deny the case based on the failure to meet the required burden of proof.
25 years into the UDRP, if parties don't understand what they have to submit by now, it's on them. In the earlier days, I think I was a little bit more active and asking parties to supplement the record and to submit something else because I really felt like there had to be more. But now I feel like it is on the parties. And I'll be particularly critical of complainants here because I see some very poor complaints. People who throw something in which has conclusory allegations, sometimes they're just a couple of pages long, and they don't provide facts. And for me to say to that complainant, oh, come on, you could have done a better job, that's actually, at this point, too bad. Now, I do issue procedural orders, especially if I have very hotly contested issues and I feel like there's something else that will really help me, or if the respondent has raised things in response that the complainant couldn't have anticipated, and I really would like to know the complainant's views on that, then I do think in a circumstance like that, it's appropriate for me to ask the complainant, can you respond to this point? But if the complainant has failed to put in the evidence necessary, then I agree with my dear late friend Richard that it is too bad for them. We take the complaints the way we find them. And complainants who are not doing a good job, who are not putting in the evidence, they will find that their case is denied, and they will not be able to refile unless there's been a meaningful change in the circumstance. It is not enough to say, let me take a cheap shot, let me not do the work, and if I don't like the results I get, I'll just try with another panelist and I'll put in more evidence the next time. What I really would like the complainant counsel and complainants who are listening in to recognize is that they should treat this as a summary judgment motion. This is your chance. Put in the evidence. Now, if you put in a statement of fact that says we've sold $100 million of products under trademark XYZ over the last 10 years, and you sign that and certify it to be true, I will accept that as a true fact unless the respondent disputes it. I'm not going to require you to submit invoices showing me the sales. But if you really want to persuade me, put in one advertisement, put in a copy of the website, make it easy for me. This is like minimum wage for me to do these cases. I get paid very, very little for these cases. I generally put 20 plus hours into these cases because I take them seriously. And so don't make it hard for me. Complainants, give me the evidence. Respondents, don't dispute everything. Don't say that the trademark and the domain name are not identical when there's one letter apart. Concede the things you should concede and focus your efforts, supported by evidence, on the things that really matter.
All right. We are almost at the end of the hour, so hopefully everyone will stay a few minutes longer so we can hear from Gerry. I'll ask one brief question, although I've got many I could ask, David. I'll pick one of the simpler ones, hopefully for you. And you talked about the confusing similarity test being a standing requirement in the UDRP. Could you speak a little about what the difference, if any, between the language of confusing and confusing similarity is? The policy mentions specifically confusing similarity. Is there any conceptual difference between confusing similarity and just similarity in the policy?
Yeah, look, when the policy was drafted in the late 1990s, in retrospect, I think using the word confusing similarity may have been slightly confusing, because if you understand the concept of likelihood of confusion, you could understand why some people might imagine, oh, this is the chance to do the whole assessment of confusion. But if we did that in the first element, we would not need the second and third elements. Words have meanings, but the meaning of words always has to be understood in context. And in the context of the UDRP, where we already have an opportunity to consider issues of bona fide use, of legitimacy, of fair use, of bad faith, when we have those elements, specifically in the second and third factor, it can't be the case that the founders intended us to do it in the first factor and then do it again in the second factor and then do it again in the third. And that is why the idea of confusing similarity is based on this straightforward comparison of the domain name and the trademark. Is there enough between those two to say, yes, these are confusingly similar, that in a way that gives you standing? If Coke wants to have a website at, what do you think of Pepsi.com? There's nothing confusing about the word Coke and Pepsi. No matter what the website's about, there's no Coke in Pepsi. So what we're really looking at in that first element is there enough of a basis for us to say, yes, this complainant has the right to be here in this UDRP, and now we will assess legitimacy and bad faith. I think in retrospect, one might say that using the words confusing similarity wasn't the very best word choice, but laws don't always use the very best words. Policies don't always use the very best words. We interpret them over time. We come to understand what they mean. The US Constitution's reference to equal protection and due process, those concepts have had a lot of issues develop around them. And I think confusing similarity, although much less important than those two concepts, I think that concept has been developed over the years. And I actually don't think there's a lot of controversy around the idea of how the first element should be applied.
Thank you, David. Camila.
Thank you, David, again from me. And as Zak mentions, we have Gerry Levine here with us, who will provide some closing remarks. So Gerry, the floor is yours.
And just so everyone knows, we've had over 100 participants so far. Go ahead.
That's really fantastic. A really fine presentation, David. Thank you. One of the failings of the Zoom platform is that it doesn't record the applause, which if we were in an auditorium, I'm sure would be deafening. Thank you so much, David. If I take it correctly, David is inviting panelists to a debate on the proposition that trademark infringement is not per se beyond the scope of the policy. Whether it should be or not is a worthy question. Indeed, debating issues has, from the implementation of the policy, been a key strength in its development of a functioning jurisprudence. For context, when ICANN implemented the UDRP in 1999, there was no settled law to apply to cybersquatting disputes. In fact, neither was there any settled law on cybersquatting in US courts. Judges had to contend with an entirely new tort that was distinct from traditional trademark infringement, but which at the same time was an infringement of trademark rights. As with US judges trying to find their way forward in the 1995 to 2000 period, so it was with panelists, when in the year 2000, armed only with the aspirational dictates of the policy, they were expected to make law. In the inimitable words of the WIPO final report, quote, efforts should be made to promote the development of a body of persuasive precedents, which is precisely what they did. How they did it and what it took to create consensus is an amazing story, but not for now. It may be remembered that the pioneer panelists who decided the first case in the year 2000 confirmed that the policy demanded in proof both registration in bad faith and use in bad faith. As that had already been debated by WIPO and resolved by ICANN in its second staff report, conjunctive bad faith became, as it were, the first consensus view. But I'm sure you will also remember that commencing in 2009, that consensus of conjunctive bad faith was challenged by a new theory of retroactive bad faith. It took 3 or 4 years of vigorous debate to reconfirm the conjunctive requirement. That particular debate was only one among many other debates that were then going on. The point of these debates, and the one that David is now proposing, challenges panelists to consider the scope of the policy. We thought we knew what it was. ICANN tells us that the scope is narrow, and I think it can fairly be said that panelists have generally construed this to mean that the policy is limited to resolving clear-cut claims of cybersquatting. But I think David is also just suggesting that this too is subject to debate. The purpose of all this debating, of course, is to influence the direction of the law. Should the scope of the policy be expanded to consider trademark infringements as a factor in cyber squatting? I'll leave that interesting question to the debaters. One final point, I think, final point. I think it's fair to say that David was among one of the first, perhaps the first, to advocate a need for consensus. He stated in one of his early decisions that where, quote, a consensus has developed, it is incumbent upon the panel to follow that consensus to promote consistent application of the policy. As the number of issues proliferated, consensus was further enlarged through debates. That enlargement continues to this day, and who knows, it may also one day include a new consensus for the jurisprudence on the issue of trademark infringement. In my view, there is no end in debating issues. Why should there be? Law doesn't stand still. As new issues come into focus, so debates continue. Whether panelists agree or disagree to this particular issue, to this particular debate, it will be stimulating. So again, David, thank you so much for a really refreshing discussion in opening up this debate on trademark infringement. Thank you.
Thank you, Gerry. Thank you, David, Brian, Zak. Again, a wonderful lecture. This was recorded. We will share it. Thank you to all over 100 attendees who have stayed with us a little bit longer. Again, want to say thank you, and I already look forward to next year. Take care, everyone.
Thank you, everyone.
Thank you.
Thanks for having me.
Thank you, David.
Thank you for
Gerry.
being here.
Thank you, Brian.